I want to welcome you here today to the importance of legacy planning. I say legacy planning and not estate planning because I am interested in more than just your money passing to the right people when you want it to. I really am interested in your people sharing your values and sharing what's important for you. I'm David Herz. Your peace of mind is my objective. I came to this work. I've been a lawyer since 1994. I was always involved in my father's planning since then, and probably before then even, and I have seen so much strife come out of poor planning. I have a friend who has spent better than $100,000 fighting her brother over a piece of land that her mother didn't leave a will for, left no instructions for. I have seen people biffed out of their houses by, how should we say, unscrupulous lawyers and family that brought influence in the wrong time and place. And you don't have to go far. There's a Netflix special that covers this, what poor planning can do in terms of trustees and attorneys taking advantage of clients. And those are things that don't have to happen. And then my father died. And like I said, while I'd always been involved in the planning, I didn't get what a huge difference a proper plan makes. And my mother and I literally had to go to a handful of brokers with his death certificate. They changed the trustees. We had one filing with the probate court and had to pay the probate filing fee, but had no other interaction with them. Even though we had differences, there was one major item on which I differed with my mother and my sister. My father had locked it down. I couldn't argue. There wasn't anything I could do. So instead of where anger and resentment could have come into the space, my father just made sure it couldn't happen. And we're on good terms, and that's what I want for you. I want your family that's taken care of, and I want your family to stay a family, regardless of what happens. So, why is legacy planning important? It allows you to declare who is going to take care of your children if you can't. It allows you to declare who will take care of you and make your healthcare decisions when you can't, and what care should be provided. It allows you to decide who is going to manage your money and your property and make your decisions when you can't, and how your loved ones are going to receive your money and your property after you pass, and when. And that can be very important. And without it, the state decides. And I promise you that whatever plan the state has, your plan, the worst plan you can come up is better than the best plan that the state can provide. There are just things that you can put into place that make sure that your people are taken care of, that the state just can't do if you haven't taken care of. So, what planning documents should you have? Healthcare power of attorney. This is where you name your representative, the person you want to communicate your medical wishes to the appropriate medical professionals, who's going to talk to your doctor for you, who's going to say when to pull the plug if you can't. The things to consider are, can they act in a reasonable amount of time, and will they follow your wishes? And I'm going to add one other thing here. Will the person be able to live with his decisions? Sometimes the person most naturally, how should we say, tasked with this decision isn't the best person to make the decision. You know, maybe you have a child or a brother or a close associate who would be much more dispassionate, who would follow your wishes, and who would be able to go to sleep well at night regardless. You know, sad for your loss, but not devastated by having had to make certain decisions on your behalf. So, you know, maybe you don't want to leave your wife wondering whether she should have tried one more thing or gone to certain lengths that she might not otherwise have gone to. Maybe you'd like her to just remember you and to sleep well, and the other way around too. It's a husband-wife, either way. Men typically die first. Anyway, so when naming an agent, the other thing to keep in mind is you want to make sure you name an alternate. Maybe the person that you named, when push comes to shove, really doesn't want to make the decisions. Maybe he moves, maybe he's not available. Financial power of attorney. This is the person who takes care of your legal affairs if you can't. They can sign legal documents for you. They can take care of your VA benefits, it depends. You can actually choose your attorney to have any of a list of powers. These are very easy to customize so that the person that you want to trust with various powers has exactly the powers that you want and doesn't have the powers that you don't want, in order to be able to carry forward your wishes and to take care of your affairs. Sometimes people end up in, you've seen it now with the COVID, sometimes people are in induced comas for a period of time, and that's, COVID passes in reasonable time. Other things can last for a long time, and you want to make sure that there's someone there who can make your decisions and access your assets and to take care of your people when you can't. And if you own a business, this is even more important, to make sure that you have a legacy plan in place there as well, so that doesn't fall apart in your absence. Your last will and testament. Now, this is where you get to choose who's going to wind up your affairs. That's called a personal representative or an executor, who's going to ultimately receive your property and your money, and these are your beneficiaries. And most important, when sometimes maybe you've got a little bit and you don't want your now 4-year-old children to get their hands on their piece when they turn 18. Maybe you want to set it aside for their education. Maybe you want them to learn how to invest it a little bit first. Maybe you want them to be protected. You want that money protected from creditors or from poor decisions that, how should we say, young impetuous adults might make. And we can tailor your documents to make sure that your children get what you want, when you want, as it's appropriate for them. If they're still minors, it will also name who will care for your children. If you can't, your will is only effective at your death. It does not avoid probate. And because of this, I'm going to add one other thing. There's one document I typically add that a lot of other attorneys don't, and that is called a standby guardian document. Sometimes you don't die, but you don't make it home in time for the babysitter. Some people get caught in accidents. People get caught, on a cruise somewhere. The craziness of COVID-19 has shown us people can just be caught in a different part of the world and not travel. And you might have minor children, and you don't want the situation where the police have to figure out with the Department of Children's Services where to put your children. If you have the documents in place, if you have a trusted neighbor, friend, relative who can care for your children when you can't, it's a really easy document to set up. And while it doesn't happen much, when it's needed, it's a godsend. Revocable living trust. This is an alternative to a will. And I'm going to not read the gobbledygook legal language that I put at the beginning there, because that's not really... Let's put it like this. A trust is like a company. My name is David Herz, right? I might have a bank account. I might have a piece of property. I might have a car. I've got some stuff. If I die, as I am, and I've left a will, all of my things will have to be inventoried by an executor and taken to a probate proceeding. If, however, I hand everything I own into this David Hertz trust, and I want you to think of it like this. If there's a company, let's say GM, and GM, the CEO, dies tomorrow, the next in line steps up and the company moves on. And that's exactly how a trust works. I put everything I have into a trust. It's not me anymore. It's called the David Hertz Trust. I could call it anything I want. It doesn't have to have my name on it. Typically, people name it the David Hertz Trust, whatever date, and that becomes the owner. And there's a legacy plan built into the trust. If the trustee should cease to be able to act as trustee, then the next person becomes the trustee. So what happens then is just like it would when a company changes. What would happen is that you would go to the bank and you would say, here's our new signatory, here's the trustee, your new trustee, David can't do it anymore, and it moves forward. It's that simple. Now, it's important. What? You're the trustee during your life. I get to be the trustee during my life. And when I can't be, then someone else becomes the trustee. I can be the current beneficiary. It's handled under my own, keeps my social security number. I don't have any special filings because of it. And having a properly established and funded trust can help avoid probate. It can avoid the proceedings. It is not going to avoid all probate involvement. You will still have to file with the probate court. But when my father died, we had one filing. I walked in, I handed the papers off, and I was done. That was it. With a will, you need to go and present your case to the probate judge, and it takes time and it takes effort, and it typically takes the involvement of an attorney. I already have these documents. I'm done. That might be the case. I'm just going to put up some factors here that if they apply to you, you might consider revisiting. First, children. How old were your children when you first created your plan? Did you even have children? You know, were you previously married? Was it, you know, if you pull out your will, does it still name your prior wife as your trustee or as your beneficiary? Have you had creditor issues? Are your children having creditor issues? Do you want them to receive things outright? Do you want to put things into a protected structure so that they receive things as a trustee should determine over a course of time? Have you moved to another state? Different states have different laws. It makes sense to revisit these documents if you've gone to another state. Sometimes different presumptions are in place and the documents need to be shifted in order to make things happen. Other named individuals. Maybe your trustees disappeared. Maybe the guardian, the happy couple that was supposed to take care of your kids if you couldn't, has since gotten divorced and both of them have moved to different parts of the country and neither of them are talking to you. Maybe your parents are getting older and what you wanted them to take care of for you, they really are not interested in doing anymore. Maybe a child has become married or divorced, or you've had another child, or there are creditor issues. You know, these are all of these events could affect the appropriateness of your documents moving forward, and it's appropriate to review them every couple of years. Changes in your life. I mentioned this before. New state sometimes brings with it new laws, and you need to adjust your documents. Also, if you have, for instance, a power of attorney or healthcare documents and you need to present them in another state, while they will be received, sometimes the bank or a credit company or the local doctor just isn't that familiar with the form, so it might require a little bit more review before what you want gets done. Banks are really picky about this. Sometimes it doesn't matter what you do, you're still going to be stuck with the banks. What should you do next? If any of this applies to you, if your life has moved on, if you've gotten richer, poorer, married, your children have moved on, your children have gotten married, your children have turned 18, and I just want to point one other thing out. If your children turned 18, you don't automatically have the right to determine their healthcare decisions if they can't. And if you and your spouse, or you have an ex-spouse and you argue about things, it's something you might want to consider, making sure that your teen has given the right person the authority to make medical decisions on his behalf, or to manage his affairs if he can't. I know sometimes it seems young, but people do stupid things when they're young too, and sometimes they get hurt, and sometimes they have things that need to be taken care of. So, what should you do next? If anything that I have spoken about here has caused you to think, what you should do next is you should contact me. I'm available for a contactless consultation via phone and via video conferencing. Fortunately, the governor of Connecticut, Ned Lamont, has put into place an order that remote authorization and remote execution of documents is now possible, so that you don't need to put yourself at risk and leave your space in order to try to make affairs in case something should happen. I don't want you to get sick trying to arrange for if you should get sick. That seems silly. You can visit CTFamily.law to schedule. There is a short scheduling for a quick consultation if you really are looking for a complete plan, I suggest we schedule it 2 weeks out. I will send you an inventory to fill out and to get back to me so that we can really take a look at what your needs are and how we can take care of you. And if you require urgent attention, I'll fix that slide later. Your best bet is to call me at 203-517-0518. Again, if you require urgent attention, just call me at 203-517-0518. Any questions, feel free to reach out, CTFamily.law, legal@thehertzes.com, or 203-517-0518. Have a great day. Thank you.